Hi, everybody. It's Jack Milligan with you again, finally, after a long absence from the Plaintiff's MSA and Lien solution here in Portland, Oregon. So, long absence. Last recording was before the Corona COVID-19 virus breakout. And yes, it's threw us into a little bit of a loop. We've had quite a bit of activity and quite a bit of interesting things to deal with during this interim. First off, most of our staff is working remotely and has been since around the middle of March. So everybody's safe and sound, and I hope all of you are too, and all your families. The interesting thing about this has been that we've had some interesting things happen in the interim. I'm now a new grandfather. My oldest daughter, Heather, had an emergency C-section right in the middle of April and gave birth to little Aaron, a beautiful little boy who is totally safe and sound, but still in the hospital. Don't expect him to be released until he goes full term around June 8th. But very interesting that all happened during this period of time. Part of what's happened by now is everyone realizes that the government and the Federal Reserve have taken extraordinary measures to pump up the economy, put money into consumers' hands, and to keep everything going during this lockdown. And behind me, I have the government debt clock. And as it stands right now, we've got a current deficit of $25,108,000,000. That's $75,347 per every person. What's really interesting is that we have total U.S. unfunded liabilities of $123 trillion, and that works out to about $370,000 per United States citizen. $370,000 of unfunded liabilities. That's Medicare, Social Security, the prescription drug plan, all of it. So, what's going to happen here? Well, we can expect that the government and especially Medicare CMS are going to have to step up collection and enforcement of their Medicare secondary payer rights, which includes both past medical, that's medical incurred that Medicare paid for related to the injuries and conditions that are the subject of your client's settlement. They're going to step up that particular recovery. And as most of you know, there's not much you can do about that, except I'm going to give you a couple of tips. Number one, defendants are still asking plaintiffs to sign a release form so that the defendant can communicate through the portal to Medicare and put them on notice that there may be a pending settlement at some point. The problem with that, as I've spoken before on these videos, is you trial lawyers give the defendants a demand letter, and the defendants give the demand letter to someone, probably at their self-insured or the insurance company that is potentially on the hook for the claim. And from there, from best we can tell, it probably goes to clerical staff who is asked to then contact CMS through the portal and begin to open the file. So you've got to imagine, what is it they're going to report? The defendants aren't going to report just the base injuries. They're going to code, potentially, everything that you put into your demand letter and report it into the portal. So if you've got pre-existing conditions that are unrelated to the accident, but you've claimed aggravation of those conditions, you are potentially setting yourself up for a very large conditional payment report that is going to have to be challenged, and you're going to have to try to reduce it on the back end when it's time to collect the settlement, pay the Medicare conditional payments, and prove to the defendants you did so. So if you want to avoid that situation, our recommendation is, best practice, tell the defendants, no, you're not going to have your client sign that form, that you are going to handle this situation, that you know your rights, you know your client's rights and responsibilities, and that you're going to take care of the reporting. So then you do it. And if it's not something that you want to handle, that is a service that we provide. So we'd be glad to help you with that, just call our office and get directions on how to do it with us or how to turn it over to us, and we'll take care of the reporting. And it'll be our job to make sure that there's nothing in that report that shouldn't be there. The second thing is that I think you're going to see increased enforcement and collection of future medical expenses that are related to your client's case. We've talked about this too, and it's part of the code already. So there doesn't have to be any new rules, regulations, or guidance issued for Medicare to collect on expenses for future medical services. Now, are they going to actually collect on that? Well, there's the potential that if they've erroneously paid, they can demand the money back from your client. But what's more likely is the bills are going to go from your client's treaters into Medicare, and Medicare is going to match those bills up with previously reported codes from the time of settlement, and that comes from the defendant's legal requirement to make what's known as a Section 111 report into the Medicare portal, saying they've got a settled case, and then the defendants will report the amount of the settlement and the ICD-9/ICD-10 codes that are being settled with this case. And that's another area where you can have a problem going forward with your client. It may happen immediately. It may not happen for years down the road when they later become eligible for Medicare, either because they applied for Social Security disability after the settlement and eventually 30 months later after application, they've been accepted and they've gotten 24 SSDI payments, and now they've got their Medicare card and they start sending in bills, and Medicare matches those bills up with what was reported in the Section 111 report and starts sending your client denial of payment letters. They don't actually send them to the client. They're going to send it back to the treater who submitted the bill. This is not being paid. We have talked about before where we've gotten a hold of these conditional payment notices, etc., where it's going out to claimants and it's showing the claimant what was billed and what was paid and what wasn't and why. So that's the big risk here, is that with all of this debt that's been created, we already had a ton, but this situation with the virus is going to add a ton more. It's probably going to add 2 or 3 tons more before it's over. And that means the government is going to have to find ways to plug the holes. So you can probably expect that they're going to increase and ratchet up their enforcement and denial of payment. How do you deal with this? Well, you deal with it on the front end of the case. You don't have to ignore it and then have it come back and haunt you. If you deal with it up front, we can not only help you with the conditional payments up front, but we can help you with that future medical issue. We're the guys that wrote the book on the 3 ways to avoid having to fund an MSA and yet still have your client be completely compliant with Medicare, not jeopardize their future Medicare benefits, and not create a long tail liability for you attorneys. Good to be back. We'll have more ongoing videos in the future. We'll have more to say about these topics. This is enough for today. It's a long video. Thanks for sticking with me and watching. Subscribe to our channel. Watch for our disclosure documents coming out shortly in sometime at the 1st of June. Watch for our CLEs that we're going to start posting and making available for attorneys to purchase on these topics. CLEs that will come with ethics credit. Great talking to you all. Hope you're all safe and sound, and we'll be back to you again in the near future. This has been Jack Milligan for the Plaintiff's MSA and Lien Solution.